I want to thank the teams led by David Boies and Ted Olson, and our entire legal team, including the City and County of San Francisco, for making our case and for demolishing their case. The truth that came out in court is that Proposition 8 is discriminatory, unconstitutional, harms gays and lesbians and their children, and does so for no good reason. That case was made by our witnesses and their witnesses. Now I'd like to turn it over to Mr. David Boies, and then Theodore Boutros will make remarks and we'll take your questions. Thank you.
I think one of the most remarkable things about this trial was how much agreement there was among the witnesses. Although it didn't always start out that way, it ended up that even the witnesses brought on by the defendants agreed with the principal points of our case. We said on the first day of trial that we would prove three things: that marriage was a fundamental right, that depriving gays and lesbians of the right to marry hurt them and hurt their children, and that there was no reason, no societal benefit from preventing gays and lesbians from getting married. And not only did we prove that, through witness after witness after witness, from Harvard and Yale, Stanford and Berkeley, University of Massachusetts, from across the country, the highest experts in the land, as well as powerful individual fact witnesses, told the story of how Proposition 8 damages gay people, damages lesbians, and damages the children that gay and lesbian couples are raising. And you heard from the plaintiff's own witnesses, the defendant's own witnesses, of that harm. You heard from Professor Young, Professor Nathanson, Professor Miller, and from the last witness, Mr. Blankenthorne, that preventing gays and lesbians from marrying hurts people and does so for no good reason. And you heard that not only from our witnesses, you heard it from their witnesses. Despite the fact that they dropped most of their witnesses after we took their depositions, the witnesses that they brought admitted that what was at work here was a religious divide based on prejudice and stereotypes, and that there was no justification, none, zero, for depriving gays and lesbians of the right to marry. And the uniform testimony that children would be better off if gays and lesbians were able to marry, I think was part of the most powerful evidence that we have. Ted Boutros, as you could tell from the court, was responsible for building up a lot of our case. I was responsible for tearing down a lot of it. He had more work to do, I had more fun. I'll turn it over to him to let him talk about how we built up the case.
Thank you, David. I think we made the right choice in terms of the division of responsibility. It was really, today and yesterday, we saw the most compelling thing I've ever seen in court. The expert witnesses hired and paid by the proponents of Proposition 8 admit a litany of facts that go to the core of what this case is about and that prove our case. Today, Mr. Blankenhorn, as you saw, he admitted a list of facts, including that same-sex marriage would likely contribute to more stability and to longer-lasting relationships for committed same-sex couples. He admitted that allowing same-sex marriage would reduce the divorce rate. That, to me, was a stunning moment because, as some of you may know, one of the arguments that they have been making is that somehow, without ever explaining how this could happen, allowing people who were in love to get married would somehow injure other people who were married. It never made any sense, and today, Mr. Blankenhorn, their expert, the proponent's expert, admitted that was false, and in fact, allowing same-sex marriage will help marriage. It will create a better attitude towards marriage, he admitted. So it was a litany of facts. The other compelling thing today, the the only witness that the proponents of Proposition 8 could find to testify on the meaning of marriage in the United States admitted he had not read one single Supreme Court decision defining marriage as a fundamental right in this country. So if you're looking for a big hole in his research, that's one. The Supreme Court has said over and over and over, marriage is a fundamental right, it's a fundamental liberty, even for people in prison. And as Mr. Boyce's questioning today demonstrated, there's a Supreme Court case that say even people in prison can get married. People who've committed murder, people who are don't even know the person they want to marry can get married, but two gay people who are in love can't. That makes no sense. It's irrational, and I think we proved it through our witnesses, through the witnesses on the other side. As you know, Mr. Miller, yesterday, the witness for the proponents, the other witness, admitted that anti-gay biases and prejudice tainted and affected the vote on Proposition 8. He also admitted that the ballot initiative process is prone to allow majorities to strip away the rights of minority groups. And he also admitted that religious divides in the Democratic Party were the critical factors that led to Proposition 8 being enacted. I can't think of more facts except for the documents and the videos that we put in that showed that hateful messages and erroneous messages about gay marriage were being put out, funneled out through front groups by the Proposition 8 campaign. So when you put all that together, I think the case is extraordinarily compelling and not even a close call.
Do you think you proved that